Well, voluntary intoxication leading to a state of automatism is once again a valid defense under Canadian law to a violent criminal offense. Viva Frei, Montreal litigator turned YouTuber, and in today's vlog we're breaking away from the American law stuff, as interesting as it might be, to get back to some Canadian vlog stuff. What's up, Canada? We're talking Canada stuff today. A few months ago, I did a vlog on a university student who consumed mushrooms, and I don't mean the portobello kind of mushrooms, fell into a state of uncontrollable delirium, ran outside in the middle of winter butt naked, broke into somebody's house whom he had never met before, who happened to be an elderly lady professor, beat her with a broomstick, then fled her house, broke into somebody else's house, and curled up into a fetal position in their bathroom before he was arrested. He pleaded not guilty by reason of automatism, and he was in fact acquitted of his crime, and people were asking me, how could this possibly have happened? I did a vlog explaining it. If you haven't seen that vlog, give it a watch. I'm gonna link it right here. In that vlog, I explained how the judge on a pretrial motion had declared a certain provision of the criminal code unconstitutional. That provision of the criminal code was specifically a provision that outlawed the defense of involuntary intoxication when it came to violent offenses. I'm going to make a short montage of the highlights from that vlog just so I don't have to repeat everything I said in that vlog in this vlog, and this vlog is going to make a lot more sense to you. We have to get clear on the distinction between voluntary intoxication and involuntary intoxication. We have to get clear on the distinction between voluntary intoxication and automatism. We have to understand the distinction between crimes of general intent versus crimes of specific intent. The distinction between voluntary and involuntary intoxication is pretty easy to understand. Voluntary intoxication means that the individual took the mind-altering substances on purpose. An interesting caveat is that even within the realm of voluntary intoxication, it is conceivable to fall into the realm of involuntary intoxication. In Canada, we had what was known as the Leary rule, which was to the effect that voluntary intoxication cannot serve as a defense to a general intent crime. The Supreme Court in Davio concluded that the Leary rule was unconstitutional with a but. The court concluded that voluntary intoxication could not serve as a defense to a crime of general intent unless it resulted in a form of automatism. And what is automatism? That is when the accused has rendered themselves in a sort of robotic, autonomous state where they no longer even know what they are doing. Now, the interesting thing about section 33.1 of the Criminal Code is that the constitutionality of that provision has yet to be adjudicated upon by the courts, but I think that day is coming. In that vlog, I also made a hard prediction on how the courts would rule on the constitutionality of that specific provision of the criminal code. I predicted as follows. And my non-milquetoast, non-fence-sitting opinion is that that provision of the criminal code is perfectly constitutional. And if it is deemed to be unconstitutional for whatever the reason, it is nonetheless a legitimate and justifiable limitation on the rights of individuals. When it comes to voluntary intoxication of substances, the very purpose for which you voluntarily consume them is to affect your state of mind. You cannot rely on your altered state of mind as a defense to violent crimes. Period. Well, at the very least, as of today, that prediction was wrong. The Court of Appeal of Ontario just came out with a decision in which they declared that provision of law to be unconstitutional and not saved in virtue of the first article of our Constitution. Let's break that decision down so at the very least we can understand it, even if we don't agree with it. The Court of Appeal decision at issue is R versus Sullivan, and it's in fact two cases that were joined given the virtually identical fact pattern. The Sullivan decision revolves around two defendants, Chan and Sullivan. Chan took magic mushrooms, flew into a state of delirium, ran over to his father's house in the middle of the night, stabbed his father and his father's girlfriend. The father later died. Sullivan's case is a little different. He tried to end his own life by consuming prescription medication. It didn't work. He woke up in a state of psychosis and ended up stabbing his mother. Both men pleaded not guilty by reason of automatism, but both men were ultimately found guilty specifically because section 33.1 of the Criminal Code precluded the defense of automatism in the context of voluntary intoxication. Now let's read section 33.1 so you know what it says, and then briefly describe the context surrounding the adoption of that provision of law. 33.1.1. It is not a defense to an offense referred to in subsection 3 that the accused, by reason of self-induced intoxication, lacked the general intent or the voluntariness required to commit the offense, where the accused departed markedly from the standard of care as described in subsection 2. Subsection 2. For the purposes of this section, a person departs markedly from the standard of reasonable care generally recognized in Canadian society and is thereby criminally at fault where the person, while in a state of self-induced intoxication that renders the person unaware of or incapable of consciously controlling their behavior, voluntarily or involuntarily interferes or threatens to interfere with the bodily integrity of another person. Subsection 3. This section applies in respect of an offense under this act or any other act of Parliament that includes as an element an assault, assault, or any other interference or threat of interference by a person with the bodily integrity of another person. What this provision of the criminal code basically says is that when it comes to assault, one cannot invoke their own self-induced intoxication to say that they lacked the intent to commit the offense. Why? Because the second subsection of that very same provision creates the presumption that having voluntarily intoxicated oneself, one has departed markedly from the standard of care that is acceptable in Canadian society. More simply put, I hope, is that subsection 2 of that same provision creates the presumption that the guilty intent to have gotten voluntarily intoxicated is sufficient to be held liable for the violent crimes committed while in that state of intoxication. And why was that provision of law enacted into the criminal code? It was enacted specifically in response to the decision in R versus Davio. R versus Davio was the case of an individual who got blackout drunk and while in his state of blackout drunkenness sexually assaulted someone. Davio pleaded automatism, that even though he voluntarily consumed all of the alcohol, because he fell into a state of blackout drunkenness whereby he was effectively an automaton, he could not form the specific intent to have committed the crime he committed. Because he could not have formed the specific intent required to commit the crime, that is to say the mens rea, he could not be guilty of the crime because he did not satisfy that second element of committing the crime. And although I suspect all of you already know this, it couldn't hurt to repeat it. When it comes to criminal law, two elements have to be proven beyond a reasonable doubt: the actus reus and the mens rea. That is to say, the actus reus is the act of having committed the crime, the mens rea is the intent to have committed the crime. And when it comes to criminal law, you have your crimes of general intent and your crimes of specific intent. Now, although there is no clear-cut definition in law, a crime of general intent would be arson, whereby someone intends to start a fire, and a crime of specific intent would be, say, first-degree murder, where you specifically intend to end someone's life. Davio argued that because the crime of which he was accused was a crime of specific intent, and because he was in a state of blackout drunkenness, even though it was as a result of voluntary intoxication, because of his state of automatism induced by self-induced intoxication, he lacked the specific intent required to have committed that offense and therefore should be acquitted. And guess what? He was, in fact, acquitted. And it was in response to that acquittal that the legislator enacted Section 33.1 of the Canadian Criminal Code, which basically precluded the defense of voluntary intoxication when it came to violent offenses. And they did this by creating the presumption that the intent, the mens rea, to voluntarily intoxicate oneself is sufficient to create the negligence required to be also guilty of any violent offense committed in that state of automatism. And the Court of Appeal of Ontario just declared that presumption to be unconstitutional. Now, we don't need to get into the nitty-gritty of the Court of Appeal's decision, but just an overview of their reasoning. The voluntariness breach. It would be contrary to the principles of fundamental justice, Charter Section 7, and the presumption of innocence, Charter Section 11D, to permit accused persons to be convicted for their involuntary acts as those acts are not willed and therefore not truly the acts of the accused. The improper substitution breach. It would be contrary to the presumption of innocence, Charter Section 11D, to convict accused persons in the absence of proof of a requisite element of the charged offense, unless a substituted element is proved that inexorably or inevitably includes that requisite element. A prior decision to become intoxicated cannot serve as a substituted element because it will not include the requisite mental state for the offenses charged. Davio. The court is basically saying that the rules of fundamental justice and the presumption of innocence means that you have to have the guilty intent, the mens rea of the offense. And if you don't in fact have that requisite mens rea, but instead it is created by a substituted element, that the substituted element itself inexorably and inevitably has to contain that requisite element. The improper substitution breach. Section 33.1 infringes the presumption of innocence guaranteed by Section 11D of the Charter by permitting conviction without proof of the requisite elements of the offense. First, Section 33.1 does not require a foreseeability link between voluntary intoxication and the relevant consequence, the act of violence charged. Second, even if Section 33.1 had required such a link, the charged violent behavior is not invariably going to be a foreseeable risk of voluntary intoxication. Yet Section 33.1 will nonetheless enable conviction. Mr. Chan's case illustrates the point. A reasonable person in Mr. Chan's position could not have foreseen that his self-induced intoxication might lead to assaultive behavior, let alone a knife attack on his father and his stepmother, people he loved. I understand the argument, but I think there are a great many people out there who might say that if you take certain types of drugs, mushrooms, LSD, methamphetamine, that nothing is unforeseeable. You don't know if you're going to flip into a state of automatism, therefore it is not unforeseeable. To the extent that it is not unforeseeable, is it sufficiently negligent to satisfy the requisite degree of mens rea to be held guilty for violent acts committed in that state? In the end, the court concludes as follows. I share the convictions stated in these authorities. Section 33.1 cannot be justified under Section 1 of the Charter as a matter of simple justice and what our law law requires the Crown to prove in order to secure a criminal conviction for the predicate violent offences. The required mental and voluntariness elements and the presumption of innocence cannot be bypassed. Finally, focusing specifically on Mr. Chan and Mr. Sullivan, there is no good reason for them to have been swept into the net of Section 33.1. Section 33.1 is overbroad in its application to them because there is no connection between the law's two objectives, protective and penal, and the law's effect on them. The justification of, quote, enforcement practicality does not apply to them, nor does the phenomenon of line drawing apply, as in Michaud, which can give rise to incidental overbreadth and arbitrariness. For these reasons, in my view, Section 33.1 of the Criminal Code limits the charter rights of the appellants under Section 7 and 11D, and the Crown has not demonstrated that those limits are justified. Consequently, Section 52(1) of the Constitution Act deems Section 33.1 to be, quote, of no force or effect to the extent of any inconsistency with the Charter. I therefore concur with my colleague in the result. That is the overview of the Court of Appeal's reasoning in declaring Section 33.1 of the Criminal Code unconstitutional. I don't think there's much doubt that this is going to work its way up to the Supreme Court so that they can weigh in on the question. So while my prediction might be wrong as of today, there is still time for it to become accurate in the longer run. The problem is that this decision does highlight certain problems with the presumption created by that section of law. As illustrated in Sullivan itself, you have different types of voluntary intoxication. You can have recreational voluntary intoxication, and you can have suicidal voluntary intoxication. And I do think we can all agree that it would violate certain rules of fundamental justice if Sullivan, for example, who only voluntarily intoxicated himself for the purposes of trying to end his life, was subsequently found guilty of assault while committed in a state of automatism resulting from that voluntary intoxication which he entered into only to end his life. So from Sullivan's case alone, I can potentially see how Section 33.1 can in fact be unconstitutional in its drafting. Perhaps the tweak in drafting to make this presumption be constitutionally justifiable would be that the presumption only exists when the voluntary intoxication itself results from an unlawful act. So it may be up to the legislator to redraft this in a way that would be constitutionally acceptable. I can certainly see that argument now. We will see how the Supreme Court rules if and when it gets there, but having read the Court of Appeal's decision, I can sort of now understand why my prediction might actually have been wrong. Live and learn, and with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. It feeds the algorithm. If you want to support the channel, we got all the support links in the pinned comment. We've got merch, Subscribestar, PayPal, Patreon, all the standard stuff. But above all else, take care of yourselves, check in on friends and family and neighbors, make sure everyone around you is doing fine, and now you know your vlog. Peace out. Booyah.